Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, took a couple days off from the channel, had to get Gun Law Junior moved back into college, and we are up at our new studios here in beautiful Post Falls, Idaho. We are at North Idaho Arms. All of their information linked up down below. Thanks to BZ and all the good folks for building us a studio here. We will occasionally be over here doing video work. If I get things my way, I will be here more frequently. Hey, we're going to talk about the big beautiful bill and NFA items all over again. There is another lawsuit now challenging the constitutionality of the NFA. This is being spearheaded by several large pro-Second Amendment organizations. We're going to go through the complaint so you can understand what's going on, and we'll talk about, does this have a chance of succeeding? So today, let's spend a few minutes and let's talk about the massive lawsuit to end the National Firearms Act. Okay, America, we're going to talk about NFA items, in particular short barrel shotguns, short barrel rifles, suppressors, and any other weapon. Why is that? Because effective January 1st, pursuant to the big beautiful bill, all of them will happen to go down to $0 taxation. Now, I recognize that many of you out there were not particularly thrilled that that's all that came out of reconciliation. I recognize that many of you thought, in fact, the entire NFA could be just completely obliterated through reconciliation. I get that many of you thought that the parliamentarian absolutely dropped the ball. Not sure if you're correct about all of that, to be honest with you, but that's not relevant to our discussion. What we are going to talk about is, we know the NFA still exists. We know all of these items, even though they're going down to $0 taxation, will still be under the purview of the NFA, which means all the extra background checks and the registration requirements and all of that. And so the question we have to ask ourselves is that constitutional? Well, today's case, which is Brown versus ATF, actually asks that exact question. It is filed in the United States District Court for the Eastern District of Missouri. This is now the second lawsuit of this nature, with Gun Owners of America filing one almost the moment the ink was dry on the big beautiful bill. This argument is brought to us by all of our good friends at the National Rifle Association, the Firearms Policy Coalition, the Second Amendment Foundation, and the American Suppressor Association, and tracks in very similar fashion the arguments that we saw in Silencer Shop Foundation versus the ATF, which was covered in this video right here. Does this argument have teeth? Yes, it does. The complaint starts as follows. Congress passed the NFA explicitly premised on its enumerated power to lay and collect taxes. And the Supreme Court upheld provisions of the NFA on that basis, holding that the NFA was only a taxing measure and that the regulation provisions were obviously supportable as in aid of revenue purpose. And of course, that relies on the case that we've already talked about before, Sonzinski, which was a constitutional challenge to the NFA, in which the court upheld the National Firearms Act not as a gun control measure, but as a taxing measure. But remember, these items are no longer subject to that taxation. The complaint here goes on to further state, indeed, the court has described the NFA as an interrelated statutory system for the taxation of certain classes of firearms. That constitutional basis, however, has recently been eliminated with respect to the making, transferring, and receiving of several items which are defined as firearms by the NFA, including suppressors, short barrel rifles, and short barrel shotguns, thus making the NFA's restrictions on those items unconstitutional as applied to those arms. Now, I want you to understand, this is not a lawsuit to absolutely undo the entire National Firearms Act, but it is a lawsuit that challenges the applicability of the National Firearms Act to these particular platforms of firearms. The complaint also states, this regulatory regime no longer comports with Congress's constitutionally enumerated powers. While the NFA's regulations may have been permissible in support of the statute's taxes on making and transferring firearms, that justification no longer remains for items whose making and transfer are no longer taxed. To the extent that the NFA imposes requirements on making, transferring, receiving, possessing, or otherwise using untaxed firearms, it cannot be justified as an exercise of any Article 1 power. Accordingly, the NFA is unconstitutional as to the untaxed firearms. Okay, so understand that the entire constitutional premise upon which the NFA had survived challenges was it was not a gun control measure. It was not even about firearms regulation. It was all about tax record keeping, and collecting taxes. Now that these items are no longer subject to any of that taxation, why then do we have to go through the enhanced background checks? Why do we have to fill out Form 1s? Why do we have to fill out Form 4s in some instances? Why is it that the federal government gets to keep a registry of these items? And for that reason, the plaintiffs plead as follows. Plaintiffs seek a judgment declaring that the NFA is unconstitutional with respect to the untaxed firearms it purports to regulate and enjoining enforcement of the unconstitutional provisions of any related regulations. Additionally, plaintiff seeks a judgment declaring the NFA is unconstitutional with respect to suppressors and short barrel rifles under the Second Amendment to the United States Constitution and enjoining enforcement of the unconstitutional provisions of any related regulations. Now, the plaintiffs here focus predominantly on suppressors and short barrel rifles. They go through what is perhaps an unnecessary analysis to demonstrate that these are not dangerous and unusual. I don't even know if that's the inquiry here, but as it relates to suppressors, the plaintiffs do wisely point out suppressors have many common legal uses. Firearm suppressors are commonly used for lawful purposes and very infrequently used for criminal activity. Although not required under the Second Amendment, suppressors increase the safety of firearm use. And so it's really hard to say that any extra regulation is necessary because these firearms are dangerous and unusual, when in fact suppressors are making the use of firearms actually less dangerous. When it comes to the two items that the plaintiffs are focusing on in this particular complaint, they also point out because suppressors and short barrel rifles are not dangerous and unusual weapons, they are protected by the Second Amendment. And there is no historical tradition that would support the NFA's all-encompassing registration scheme for suppressors, short barrel rifles, or any other protected arm. And think about this for a second. Many of you said this, and I agree with all of you who say it, that there really is only one reason to have a gun registry. Now, the federal government was able to justify it through an ulterior motive, which is, well, we need it for tax record keeping. Okay, be that as it may, now that we don't need those tax records, what's the reason that you have a gun registry now? And as the plaintiffs, using some historical analysis themselves pointed out, there can be little doubt that had King George III sought to require the colonists to register all of their firearms with the crown, it would have provoked a polemical reaction by Americans invoking their rights as Englishmen to keep arms. While the Supreme Court has posited that licensing regimes may be designed to ensure only that those bearing arms in the jurisdiction are in fact law-abiding responsible citizens, registration is wholly unnecessary for that purpose. Okay, so in summary, you may have been able to justify the existence of the NFA to these firearms when we were all talking about collecting taxes, but now that we're not collecting taxes, what's your justification? There isn't any. Specifically, though, what are the plaintiffs asking for as it comes to remedies? That's right, we got to talk about remedies, because remember, you don't really have a lawsuit unless you're asking for remedies. What are the plaintiffs asking for here? A, declare that the NFA's requirements relating to making, transferring, receiving, possessing, or otherwise using untaxed firearms exceed Congress's enumerated powers, both facially and as applied. B, declare that any regulation promulgated in whole or in part under such requirements are unlawful. C, declare that such requirements and any regulations implementing them violate the Second Amendment with respect to suppressors and short barrel rifles, both facially and as applied. Oh, they're not done there. They want more. D, enjoin defendants and their employees, agents, successors, or any other persons acting in concert with them from implementing, enforcing, or otherwise acting under the authority of the NFA with respect to violations in any way predicated upon the failure to comply with the NFA's unconstitutional provisions pertaining to making, transferring, receiving, possessing, or using untaxed firearms, or in the alternative, untaxed suppressors and short barrel rifles. Okay, so the case once again is Brown versus ATF, filed in the United States District Court for the Eastern District of Missouri. Let's also remember the case of Silencer Shop Foundation v. ATF, which is filed in the United States District Court for the Northern District of Texas. Today's complaint is going to be linked up down below in the description box so that you can geek out on it for yourself. You don't have to take our word for it. We are obviously going to very, very, very carefully watch this. Once again, this case is brought to us by the National Rifle Association, Firearms Policy Coalition, Second Amendment Foundation, and the American Suppressor Association, which means we got links down below so that you can show all of them some love as well. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, cool. You click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From North Idaho Arms here in beautiful Post Falls, Idaho. Thanks for watching and stay safe. They're saying, you know, what happens is these people get involved in these situations and then they're just denied coverage.
Yeah.
And I think that the model of what some of these companies run, as far as they run like insurance companies, actually leads to that result a little bit. But, you know, that's a fair criticism. People are going to invest money and you're going to be there when it hits the fan, and then it hits the fan and you're not there anymore. What can Right to Bear say that's going to make them different?
Well, yeah, I think that's a great point. You know, I come from the insurance industry, so I know it well. I know that insurance contracts are written by attorneys for the benefit of the insurance company, not the insured.
That's right.
So what we did at Right to Bear is, you know, we're first off, we're gun people that are in the business of supporting gun people. When we started the company, we knew of the numerous other players that had this market pretty captivated at the moment. And after reading their contracts of everybody, we determined that, hey, we can structure an arrangement that gives people and really the citizens of our country somebody that's going to be there when they need us most. That was what we prided ourselves on, and I know that sounds like a marketing piece, but it's the truth. That's why we started the business, right?
You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.